to be escorted to the IPO offices to seek whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was duly booked at Langata Police Station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter, which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sua generis document which sets certain conditions, which is replica of the conditions imposed under Section 36A of the CPC, and also, Your Honor, which technically it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the teeth from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as an attorney at law, Your Honor, he has been told categorically that he should report to the OCS, to the Eldoret police station. So there is also a condition, Your Honor, to demonstrate that is not a flight risk. There are already safety mechanisms which have been imposed by that interdiction letter, Your Honor. We'll also invite you, Your Honor, to consider the primary consideration of bond and bail. That is to secure the release of an arrested person as and when required. And irrespective of the issues, Your Honor, whether there will be any intended charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the situation, Your Honor, we will humbly persuade you to adopt a latitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, we will humbly invite you to adopt the philosophy of in Justice Kimaru, as he then was, in Michael Rotich versus Republic, whereby, Your Honor, it's an authority from pages 22 to 26. Whereby the judge here, at least in this decision, Your Honor, conceptualized and also reiterated the importance of liberty being in pressures that are personal liberty. Right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offense has been disclosed which can result in such a person being charged with a disclosed offense. Your Honor, the reason why we are citing this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. Reasons being, Your Honor, I had a privilege of interacting with this decision, Your Honor, when my then client, Major Rotich, may his Lord rest in peace, was arrested, and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and this liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor. And we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which we have also furnished you, that is in Kenneth Omondi, Ojwang, and 38 others, whereby the same judge also reiterated and illuminated the law, knowing that there was a development, because between that Michael Rotich and this Kenneth Omondi decision, Your Honor, there was an amendment to Section 36A of the CPC, so which drastically changed the law. That's why we will also adopt the reasoning of the judge that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the prosecution is seeking extension of time was first to inform the arrested person of the likely charge that he or she may face, and secondly to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also We'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is verse 1 to Article 49, I think 1A, 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also, we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed aboard, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we'll humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bail and bond policy guidelines, which will guide you, especially on the situational analysis. And we'll also beg to ground our application also, Your Honor, and to support the same also, as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Gimji Malde versus Republic, whereby the Court of Appeal settled the issue and reiterated the constitutional provision that an arrested person has a right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offenses such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which we have been told that there are compelling reasons, except the question of interferences, safety and interest, Your Honor. We'll also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo in Republic versus Danfo Kabage, and I know my learned senior Cleveland Better also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court. And mere allegations or possibility is not enough. And bail cannot be refused simply because the accused has been charged with a very serious offense. And that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We'll also rely on the other decision which we have tendered, Your Honor, the Betty Timotai Kimeywa case, which was also a reaction to the Michael Rotich case before the amendment, and we have already furnished to you, Your Honor. And as such, Your Honor, we'll invite you to decline the application before you because the same is bereft of meat and substance to stand on, and to invite you to unleash your sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. And we'll humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions of the officers. And also, Your Honor, in also making your ruling, Your Honor, we'll humbly invite also you, Your Honor, to make certain policy, or in your dictum, to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the